relationship, that which we call the employment relationship, which is based on an employment contract, which can be written down or which can be a tacit contract where it has not been reduced to writing, but all the same, the Labour Act requires that the contract be reduced to writing in terms of Section 12 of the Labour Act. And this relationship is governed by that Labour Act, which is the supreme source of labour law apart from the Constitution. Now, there are reciprocal rights and duties arising from both parties, which we are going to be discussing here, part of which is the employer's duty to receive the employee into employment as well as to provide the work. And on the other hand, we have the employee's duty to provide service to the employer, which means that they have to make themselves available in order for them as parties to perform their reciprocal duties towards the fulfillment of the contractual relationship.
Mr. Monta, let me come to you on this. I think I'm happy that you highlighted that for us, because what then makes this, what ruptures this relationship, Zvataro na Honorable Ishkuti, both sides have an obligation to fulfill. But where do we find the rupturing of this relationship? Kanaguti, where are the ties severed between these two? Who would have been in breach of contract at what point?
Ndanchida kuti nditange by getting back to having an appreciation of what an employer is,
right, in
terms of the Labour Act. So if you get to Section 2, which gives us the interpretation of words, it says an employer, I want to read this one, mean any person whatsoever who employs, then it goes to say, or provides work for another person and remunerates, or expressly or tacitly undertakes to remunerate.
Right.
So from where I'm standing, you will realize that an employer is defined in various ways. He can become an employer simply by providing work. He can become an employer by remunerating or promise to remunerate. Those are the three definitions of the employer in terms of the Labour Act. Now, I also checked the Labour Act in the other relevant regulations. I couldn't find an area where it specifically says that an employer is supposed to provide work. I don't know whether I made myself clear there.
I'm following.
So what am I saying? I am saying generally the rule is to say that the employer is not supposed to provide work. But what does that mean? Does it mean TQ Kanatina say we've got a cook? Mwezi wopera Q umbadara mari yake, but hauna kumpaka na basa. Do you cease to be an employer?
Right.
In terms of values, you will be an employer. And it. But now, toda kuti tinde padhuze zvakare, mama ndibvunza question, mukati what really brings this relationship together? There is this aspect yagara yataurwa na advocate here, to say that the employer have got this duty, in course I put it in course, to provide work, which becomes something of substance to the employee. And the employee in turn is supposed to tender his or her services, her personal services, if I underline that one.
For the work provided.
That actually makes a contract.
Right.
So, yes, an employer generally is not expected to provide work, actual work rather. But you realize that pega, but not there is a general position pane ma-exceptions anopiwa, pane zvimwe zvimikana kana zvinodi zvinovhurwa. Mukana uyu manje definition iyi haingakwani pamunhu watingati isusu solely depends on commission kuti aene mari yake.
Okay.
Otherwise you work in insurance, mari yako inoiwanayo kana waunza maclients kana waita chakati. Saka tikati employer is not supposed to provide the work, actual work in that circumstance, hatisi kuita zvinhu zvakanaka. Ndo exception yekutanga. Yechipiri, pane vanhu vakaita sema-surgeons, pane vanhu vanoita tingati ma-generalists, handiti, vekuti your skill actually develops every time that you do your work. Vanhu ivo vanonzi futi vanofana kudi kupiwa basa. Saka employer cannot say handina that fundamental duty yekuti ndiprovide work. Lastly, on the exception, ndaona pane vanhu zvakare, ndataura ma-journalists handiti, kana kuti vanhu vakaita sema-actors vekuti basa ravo ukaritarisa depends on publicity. Saka ukanyima munhu yeye basa iroro, otherwise uri kumunyima publicity yake where he benefits or she benefits. Yes. Saka uchaona kuti kana employer akatadza kuprovide the actual work yachona iyoyo under those circumstances, that's where an employee can actually try to sue the employer kuti amprovide that basa nekuti anenge achimudamage in those areas. The employee equally is supposed to provide personal service. Vaya pandogara ndichiti hazvingakwanisi kuti chero une twin brother yako kana kuti une mudzimai wako haumutumi kuenda kubasa because you contracted your personal services.
Right.
Yes. Okay.
Interesting. Thank you so much for clarifying that. Perhaps we can now rep in Honorable Cho into the fold as well. Good morning to you, Honorable. Thank you so much for joining us on Capital. Awesome. I understand you've been following, thus far. So just maybe continuing from what Wabonda was saying there. Ta establisha ma roles ari ku exista pakati pa employer na employee. Employee manje ouya ozotadza kuita zvaari kufanira kunge achiita, in this case ma-services ake yawo, and then they don't do as stipulated. What are the repercussions or the consequences following that? Because employer pamwe aita zvaari kufanira kuita, asi employee manje aita kunge a short change a relationship. So what happens in that regard?
When the relationship between the employer and the employee is primarily on the contract of employment, and the contract of employment specifies the terms and conditions of employment. And in a case where an employer has provided work and an employee fails to perform, that actually amounts to a breach of the employment contract. And the employer is a number of remedies that are provided for by our labor regulations. You can actually then invoke disciplinary measures against the employees for failing to perform his duties as specified in the contract or as agreed tacitly. And this may ultimately lead to an employee being dismissed from employment.
Interesting. Would there occur any instance where the employer would be at fault anyhow or fails to uphold their end?
Yes, definitely. I want to bring in this aspect where we want to emphasize that within the contract of employment, the duty and mandate of the employer sits and resides on him providing the actual work as the contractual basis. In the event that the employer does not provide the actual work, he remains indebted to the obligation of remuneration based on the contract of employment.
So essentially, the employee cannot be faulted for that.
The employee cannot be, as long as the employee is shown up and is available to perform his duties. It is the prerogative of the employer to ensure that there is work available for the employee to perform.
Interesting, quite interesting. Honorable Gori, maybe wrapping you back into the fold as well. You spoke at the beginning about the contract of employment and perhaps how it presents itself. I'd really like to know in that regard as well. What happens? I understand you also then stated that it could be in writing or it could be otherwise. But in the instance that it is not in writing, what are some of the consequences that might occur in that regard? Because obviously, if it's not in writing, we might witness, some inefficiencies in that regard. So if the contract of employment is not in writing, what are we likely to witness in the event that there are some altercations?
Thank you very much. As much as we would want these contracts to be in writing, it is quite true and often that they are not reduced to writing. Somebody is just taken from the street and say, "Wawana basa," and this is a workstation, this is what you do, and it's never reduced to writing. In most cases, there's a promise that your contract is coming, but it never comes. What then happens is that this contract is going to be premised on what the parties said to each other and the behavior of the parties thereafter in terms of what the employee was doing towards performing their contractual obligation and what the employer was doing to also uphold the same. Main problem is where, for example, the employer does not remunerate the employee as per the promise. Then there's a dispute. The employer says, "I didn't promise to pay you $300. The employee says, "Yes, you did, but now you are paying me $100. And there's a dispute. And there are regulatory authorities that are there to deal with matters as and when they arise in any employment setup. There are what are called national employment councils, and in the absence of those, there is the Ministry of Labor and Social Services. And in most cases, where there is a dispute of that nature, the employee will have to seek remedies available to them and say, "I am not being paid as per the contract." Whilst the employer say, "No, the contract did not state that I was going to pay you that much." Now, against that background, it is the employer's duty to provide evidence of a contractual and legal relationship between these parties. So where there is an employer's word against the employee's word and the subject of the dispute is not reduced to writing, because it was the employer's duty in the first place to produce the contract and present it to the employee, most likely it is the word of the employee that will be taken. The flip side is also that, let's say this dispute is around failure to perform to the expected standard by the employee, and the employer is now seeking to take that person to task. The first question is, was the employee made aware of what is expected of them?
Right.
Was there a performance standard set? Was it agreed upon? Was it based on what we call smart performance standard? In that there are specific, measurable, attainable, realistic, and time-bound. And if it is not reduced to writing, again, the employer has the duty to prove, because they are the ones who are alleging that you have acted in a manner that is not consistent with the fulfillment of the express or implied conditions of your contract, and therefore want to take you to task. The employee says, the expectation based on what? You did not give me a job description. And now the employer is now saying, but you have been doing this job for the past 2 years, so you know what you're supposed to be doing. But the bottom line is, it was not reduced to writing, and there is a principle which says, he who alleges must prove. So the employer ought to have reduced the contract, not only the contract, and the job description in writing. And this is where we will go to the next discussion, where we are going to be talking about any other duties as specified in a job description. What are we saying? Where are we going? Where are we coming from?
And maybe if I can probably also add to what Honorable Gore is saying here. If you even go to the Labour Act under Section 128, it mandates the employer to keep records of employment for a period of 3 years. Meaning to say that that conduct of employment which Honorable is referring to in the job description is part of those records. So if you don't do that one, it is still the word of the employee that is going to be considered. I have seen that many employers, especially in the SMEs sector, they don't want to give their employees contracts in writing. And their defense is always saying, that's not a relationship ne employee, just because apana a written contract, which is a wrong position as well. And because honorable wataura about tinotarisa macircumstances, the total circumstances tinongozozviona kuti munhu aidi aisevenza.
Iwo macontract acho, is there a stipulated time frame as well yekuti pamwe anofana kunge achisvika apa, or maybe dzimwe nguva maybe the main reason why they would take it for granted is pamwe kakangori ka piece job or kakari kabasa kadiki diki, and therefore in that regard the assumption will be, why is there need for a contract if you are going to be working for me for a period of pamwe a week or a month or whatever?
Labour Act yedu yakanaka chaizvo inoti pamacontracts aya akasiyana siyana vachiziva kuti employer you've got different needs. Kune ma-hourly contracts chaiwo yekuti pe-hour unofana kupiwa contract yako kuti usevenza upiwa mari yako. Kuna anenge ari seasonal anoenderana nokuti pose industry yenyu inongodi inooperatewo seasonal, munopiwa akaderewa. Kuita ma-fixed term, kuita ma-open-ended atinowanza kuti ma-permanent aya. Saka ese aya ma-tools ekuti an employer can make use of, and ane ma-different periods awo zvakare.
Interesting. Wrapping back Honorable Mchowa into the conversation. Now, when we go to any other duties, clarify for us exactly what we mean in that regard, and stipulated in the Labour Act.
Thank you. What is expected for an employment relationship is that it has to be formal, and by being formal, it should be guided, like what my other two speakers have already mentioned, by a contract of employment. And one of the things that should accompany a contract of employment is a job description, which specifies exactly the tasks that an employee is supposed to do. Then when it comes to any other duties clause, specifically this clause is not opening up the duties of the employer to reference, as we would say, but these duties are duties that must be related to must be reasonable and be related to the primary job, and they should not bring in a fundamental change to the nature of the person's job. Maybe just to give as an example, when someone is employed as a boiler maker, involved in the fabrication of items, all the duties that relate to, he can do lower level jobs like maybe small weldings and so forth. But when then the employer then says to him, today our accountant not there, or our receptionist is not there, I want you to go and sit as the reception. This is a fundamental shift from the nature or the job that the person is employed to do. So our law frowns on such act by our employers. It must remain within the confines of the nature of the job that one has been employed to do.
Interesting. Advocate, maybe you want to go deeper with it as well in terms of this line of thinking as well.
Yes. You know, when we say any other duties, I know most employers like that phrase. Any other duties as may be specified by the employer from time to time. But I think there needs to be clarity in the sense that these any other duties, they have to be related or job related, in the sense that there must not be a substantial variation of the contract from the original contract now taking place because of this clause of any other duties. And I think Honorable Shaw has captured it very well when he said that you cannot expect a boiler maker to then go and be an accountant, because if you do that, then the employees are literally at the mercy of the employer, because you are not employed, but you are employed as an accountant by an airline company. You are not a pilot, and your boss says go and fly that plane, and you say no, I can't. That's not my job. You can be dismissed for what? For refusal to obey a lawful instruction, because they are saying your contract said any other duties. So that phrase must be used sparingly, and employers must exercise restraint when seeking to enforce. Whilst on the other hand, we look at the issues to do with the flexibility of the employee in maybe being able to take up an extra responsibilities, but that are aligned or related to what they already do, but not to say that you substantially shift and you ask the manager, operations manager, to go and clean the toilets. That's a substantial variation, and unilateral for that matter, of the contract of employment. Remember, we said this relationship is a bilateral relationship. It is based on the consensus between the parties regarding the nature and extent of the relationship. And if the employee is not ad idem to the fact that they were going to be asked to clean the toilets, then there is a material breach of the contract on the basis that there is no consensus ad idem, and therefore there's a problem.
Ndimojambira futi ipapo Kyuka. Uchaona kuti zvinhu zviri kutaurika apa ndezvekuti hatisi kuti employer ape mushandi basa which is in conflict with his primary mandate. Akamupa manje ka zvichataura kuti tiri kupa munhu basa raasina skill to do, raasina capacity to do. Saka definitely this person is not going to what? To perform. Saka ndo anenge ari machallenges. Ndinoona zvangu magood example andinowanzoona ende kuti ngatitorewe Kyoka deri papo. Mazuva ano handiti tichita school handichita sei? Unogona kutotumwawo kunzi ndaunotora mwana wabhosi wako kuchikoro, uye naye handiti zvine zvichava related here nebasa rako. But I know sometimes vamwe vanobva vamhanya vachidera ndo zviri kunzi ngazireke kuva in conflict.
Yes. Now, when something like that occurs, maybe coming to you, Honorable Mcho, when something like that occurs, what then are the steps to maybe then rectify such from an employee's point of view? Ndinotemera kuita sei kana ndaona sekuti izvi zvakuita sekupesana nezvinhu zvandakatemera kuita naemployer wangu.
Thank you. The first point of call that is carried in any relationship is primary, firstly, dialogue. Is to engage the employer, and in a friendly or in environment, you explain yourself, right, before we resort to any legal recourse. But then also various employment codes of conduct provide for grievance procedures which are available to employees to pursue in order to seek redress. But if this continues unabated, it's one of the factors that can lead to what we also know as constructive dismissal, where employee is frustrated out of the job due to such tendencies by employer to just throwing him around, and there is legal recourse that can be obtained through the National Employment Council, through the Labour Court. These cases and the cases can rise as far as the Supreme Court, but the law protects employees in such cases.
Interesting. I'm glad to know that there are ways and channels to perhaps then further the conversations. However, how often does this happen, advocate? You spoke about sometimes uneka kuchikaka wanenge wakuta kuti ndikazodaro kuna employer wangu, maybe I'm at risk of losing my job, even though you might be protected. But how often do then people go that route? Does it, or maybe it has to be something very, very severe, like you mentioned, Kuti. It's now really opposite from what I'm supposed to be doing on a daily.
So, in terms of this relationship, the employee has got a duty to obey lawful instructions. Now, this is hinged on the contract of employment as well as the job description. Both parties must have a clear understanding as to what is expected of the employee. This is where, when the employee feels that this instruction is not lawful, they can be bold enough to say, no, I cannot and I will not carry out this instruction because it has got nothing to do with that which I was contracted to do. And they have to prove that the instruction was not lawful. And if the employer chooses to dismiss an employee or even to apply any disciplinary sanction against them for failing or refusing to obey what they perceive to be a lawful instruction, the employer has a duty to prove that that instruction was lawful. And if we apply the reasonable person test, any other person would have conformed to that instruction. But if not, then it can then be deemed to state that either that disciplinary sanction or dismissal in the worst case scenario was not lawful to the extent that it was for a reason where the employee was expected to obey what could easily be deemed an unlawful instruction arising from the employer.
Interesting. Question here on the WhatsApp that says, "Hi Skata, is it not illegal, therefore, for someone to employ somebody without a contract? In certain instances, employers deliberately just don't give contracts in order to circumvent certain obligations." I wonder, you want to take that one?
Zvatsanangurwa zvakanaka navagore kuti muZimbabwe contract yedu inogona kuva in writing kana kuva oral. Saka the assumption ndeyekuti iwe kana uri pabasa matombogara pasi naemployer wako mukataurirana mukawirirana zvamawirirana, chamusina kuzoita chete kuformalize your relationship in writing, but zveshuwa hapana chakaipa kudero.
Interesting. Thank you so much for coming through with your question. I do hope that you've been answered there. It's 10 minutes before we get to 10 right here on Capital 100.4 FM, Harare's Heartbeat. And of course, the first hour of the Capital Crunch on a Wednesday, just of course, Workers on Wednesday, labor relations as well. We'll take a short breather. When we come back, we continue with our conversation. Do stay with us. So, talking about music.
Capital 100.4 FM.
Updates, the news update.
Up with the best music. Up with the best voices. Up with the latest info. Capital 100.4 FM at 7. Hottest heartbeat. Hashtag 7 Land Up. 100.4 FM, the ultimate radio frequency for Harare and surrounding areas. Capital 100.4 FM at 7. Hashtag 7 and up.
Capital 100.4 FM. Tune into the life-changing radio. Capital 100.4 FM.
Reach your potential clients. Shout about your products and services and send out your message loud and clear to thousands of potential customers. Do it today with Capital 100.4 FM. Enjoy flexible advertising packages and professional production. With Capital 100.4 FM, your business will grow. To advertise, call Simbarashe Tizora now on 0772 943 270 or email simbarashe.tizora at capitalfm.co.zw today. Capital 100.4 FM, Harare's heartbeat.
As long as you're making yourself aware, pay is no additional pay applies where you did not.
8 minutes before we get to 10 o'clock, right here on Cappy Talk 100.4 FM, Harare's heartbeat. An interesting conversation right here on Workers on Wednesday, aligned to the general thing that appears between the employer and the employee. Of course, the employment contract as well being the center stage of this conversation. But of course, we get into a bit of a news update, as we always do each and every week, in terms of what exactly is happening. The Sunday Mail of 6th of October 2024 has a headline that says USD salary rise, bonus for civil servants. Mabonda, obviously so many happy faces would appear in regards to that news as well. How far true is that that headline?
Yeah, it's quite true. I also had my trade unions Achita confirm that, and it's also refreshing to see the public employer, the government, actually leading the pack, because we always discuss about this my issues eku improve my conditions evashandi. Saka, whatever the percentage, whatever the direction, but that's a good direction. Kana anga achinza anga achimbo tambira 253 akunza akuinda pa 296, there's something meaningful chekuti you can touch on, you can rely on kuzi. So I think that's a commendable direction from the public employer. In the private sector should also follow. Yes,
absolutely. And of course, something else in that in a different space, the Ministry of Public Service, Labour and Social Welfare put out a public notice that reads as follows: the Ministry of Public Service, Labour and Social Welfare does not charge for any of its services. Be wary of fraudulent social media posts claiming otherwise, especially those targeting job seekers. These scams are false and potentially harmful, and we urge you to report any such incidents to our office immediately. Let's work together to prevent fraud and protect our community. Feel free to share this message to help us spread the word and prevent scams as well. And it is obviously disturbing, and I would like to believe for them to issue out a notice like this, something should have happened along that regard.
Yeah, that's also a cautionary statement, like you are rightly saying. Kune mabed apples pega basket rakanaka kuti saka kuita guard against izvo kuti varambe vachiemphasize kuti isusu as public service tiripo pakupai maservices free of charge, hapana ari kubhadhara mari. Saka kana iwe ukaendawo ikoko ukanobhadharawo uri kubhadhara asi hazvisi pamutemo ndezvako ndo zvimwe zviya zvokunozopedzisira wakunzi wakuita kana corruption things like that one. Saka vanhu havabhadhari ministry yekuti uyai musevhiwe kuma-labor officers mahara, uyai musevhiwe kuma-offices kwavo mahara.
I think many a time kusatoziva kazhinji kacho, and I think rightfully so, this is a very timely notice as well, so that people are in the know and are conscious, because these things are actually, these scams are happening, across the country.
Not only that, Kakyu, remember isusu tatongojairawo sevanhu kuti pega pega padada kusevhiwa unoda kusiya kana dhola, kutenga airtime, tenga drink, tenga chandiri, zvinogona kunge zvakuda kuitikawo futi ikokoko. Saka vamwe vanogona kuzotora semukana kuti ndinogona kana achindipa $5 ndogona kakureza kana 10 kana 20, zvinhu zvakaita saizvozvezvo. Handiti takazoona last time kuya kunzi kune kuUK handiti kutova kutotiwa yamatips anenge apiwa aya ari kunzi ngavanganzwe panzvimbo imwe chete mokoverwa mese. Yes.
Interesting. As we wrap up our conversation for today, going back obviously to the main subject, what do people need to be aware of? I personally learned a lot of things during this particular conversation, especially in regards how these contracts works, and the different kinds of status of contracts as well. So Advocate, I'll give it to you first. What are some of those things that we really need to be worried about when these conversations arise?
The parties to an employment relationship ought to reduce their contracts to writing. It saves both the employer and the employee, and it also gives direction to the employee as to what exactly are the employer's expectations from me. When they forget, they go and refresh their mind using the job description. So it is important when we enter into this relationship, it's because a need is arisen. The employer needs the services of an employee towards the performance which will lead to the attainment of the overall organizational goals. The employment relationship is not child's play, and there are investments that are at stake that needs to be protected. And therefore, the best way to safeguard that investment is exercising and practicing good employment practices, as well as abiding by provisions of the Labour Act. The guideline in Section 12 of the Act is very clear and critical about what are the expectations in an employment contract. Thank you.
Honorable Mcho, your parting shot in regards to today's conversation.
Thank you. My parting shot is that in this relationship, both the employer and the employees have specific duties to confirm. Therefore, like the previous speaker just mentioned, it's important that before resuming duty, let the parties reduce everything into writing, because when you've already started working and worked for some time, it is very difficult to then demand for the employment contract. And it is also, despite the difficulties that maybe economically we go through, employees should also be aware and not allow themselves to be exploited or devalued in terms of their position. As we have seen that the issues of mental health challenges that we currently faced with, some of them are actually emanating from this nature of employment contracts that are not specific, where a person is just less vulnerable to various abuses at employment workplaces. So it is important that we have contracts that are specific and clear on the onset.
Interesting. And finally, Abonda, your parting shot.
Thank you, Q. I'm simply saying that let's engage in a mutually respectful way as employer and employee. Let's exercise good faith. Atiregere kuita kupanishana kana zvikanzi any other duty, let them not be conflicting the primary duties. kana zvikanzi hauna general to provide work usada kupenalize munhu. There are psychological effects to that.
Awesome. Gentlemen, thank you so much for your time.